The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you, Madam Clerk. I want to welcome the lawyers to the Fourth Circuit today. I'm sorry we're not with you personally in Richmond, but this is the best we're going to be able to do for this proceeding. Now, Mr. Davis,
yes, sir.
You're here for Juanita Britt, and this
yes,
is
sir,
case number 90. This is case number 19-2177, Britt versus Saul. And Mr. Davis,
yes,
we're pleased to hear from you, sir.
Thank you. Your Honor, as he said, my name is William Davis, and I'm a member of the Robeson County, North Carolina Bar, and I represent Mrs. Britt. Mrs. Britt applied for disability, alleging several things that is wrong with her. And at the hearing before the ALJ, she testified that she, as far as the work is concerned, she performed several jobs with different employers, preparing food, decorating cakes, and washing dishes. And that some of these jobs required her to be on her feet all day and may lift up to 100 pounds in some cases. And she also testified that she had surgery on her right foot for bone spurs and drop arches, which was performed by Dr. Ricardo. And recently, I think it was in 2016, 18, her doctors advised her that she needed surgery on both of her feet. But she has not been able to get that done because she didn't have any medical insurance. Now, in her testimony, she indicated that she cannot stand on her feet for more than an hour, that she's in constant pain even standing on her feet. She can sit for about an hour, and that when she was working, that her employer allowed her to sit or stand alternately. But for a while after that didn't work out, he told her that because of her problems, she was slowing down her work, and I think she was wasn't able to do the work. As far as some of her functions, she can only walk for short distances, and she has to stop, and then she has to sit because of the pain. And she has pain in her hands and her wrist, which affects her ability to lift things. And because of that, over the period of time, her doctor has prescribed different assistive devices to help her with her walking and her pain. To take the pressure off her feet and ankles. And even with those devices, it did not relieve the pain in her feet. And because of the pain, constant pain, she has to lay down and elevate her feet for 1 to 2 hours to get relief. And for her reflux, she's on medication. She has to take the laxative to use the bathroom. And she, the side effects for medication cause her to have diarrhea. She had pain dealing with acid reflux, and the pains are sharp and they last for an hour. She recently started receiving counseling for her mental impairment involving, she was diagnosed with depression, anxiety, at Premier Behavior Clinic. And over the time, her doctors increased their medication because it wasn't sufficient. After hearing the ALJ proposed 2 hypotheticals to the vocational expert, the expert found that she couldn't do her past work, which was fast food worker, which was light work, and she worked as a cooker helper, which was medium work. And she found that she couldn't do that work, but they found that she could do work at the light level in dealing with several other jobs that he identified in the record. And he proposed, like I said, he proposed 2 hypotheticals to her. And despite of her limitations, the ALJ found that she could do other jobs. Now, in evaluating her claim, both the ALJ and the district court used the 5-step evaluation process set forth in the regulations. And he found that she had not engaged in gainful employment and that she had several impairments dealing with irritable bowel syndrome, bone spurs, bilateral plateau, and a major depressive disorder. And despite the fact that there was substantial evidence, medical evidence, diagnosing her with chronic pain, acid reflux disease, the ALJ found that these were not severe impairments and found it to be non-severe. And the pain, which all of her doctors diagnosed and elaborated on based on their clinical testing, he found that she's been treated at a pain clinic. Therefore, he found that the pain was not a severe impairment. And for the acid reflux, he found that was severe because she was taking medication. At step 3, he found that her physical impairments, the muscular impairments, did not meet an equilibrium because it did not cause her to be able to ambulate effectively. In other words, he found that she was able to walk without any device. And this finding is contrary to the evidence, medical evidence from her treating physicians over the last, from I guess beginning in 2011 up to 2016, 2018. All of them basically diagnosed her with having pain. As far as the mental impairment,
Mr. Davis, Mr. Davis, this is Judge King. Is it your position you can't walk? Is that what you're saying?
She had difficulty walking. She's in pain if she does walk. I guess
she's
you could say
if she walks. How old is she, Mr. Davis?
Judge, I think she's in her. She was classified as a younger individual because of age. I forgot. I had that in front of me, but she has been. I think she was 46 somewhere along about the time she started, and over time
46. When she started, or 46 now, which is, what are you saying? How old is she?
Oh, she was 46 at the time of the hearing, but I don't have it in front of me right now. Sir, that was in the hearings in 2017 when they had the hearing.
So 49 or 50.
Yes, sir. And like I said, this pain on a scale based on the clinical testing by her doctors, because of I guess.
What did the ALJ do wrong? What did the ALJ do wrong? And what did the court do wrong?
Well, as far as dealing with her, first of all, it's step 2. For as determining her severe impairments, he did not properly evaluate and weigh the medical evidence for her treating and examining physician. He did not even mention their diagnosis, their opinions, and things in making his decision. Not only medical evidence, evidence that he appeared to weigh based on his decision was that from the state agency, which was a non-examining person, and he gave that particular examination review limited weight. He didn't list any weight or mention or assign any weight to any of her doctors that she had been seeing since 2011, even though their medical evidence is substantial based on the record. And she had about 4 or 5 different treating and examining physicians beginning, like I said, since 2011. None of that was for trying to determine her impairments. and her residual functional capacity, none of those, none of her physicians' opinions were assigned anyway. In fact, I don't think he mentioned them whenever he was trying to determine her.
Now, the he here is the ALJ?
Yes, sir, the ALJ.
ALJ.
Yes, sir. He just disregarded all of her medical evidence, and he didn't give any reason as to why. And like I said, the only evidence he appeared to evaluate in making his decision was that from the state agency, and that was a non-examining physician. And he gave that evidence a little weight. And as far as and she has substantial medical evidence from her treating and examining physician over the years, going through the date of hearing and after. And he didn't, other than mention them, he didn't either weigh or evaluate that. And their opinions is based on an extensive treating relationship over, say, from 2011 to 2018 up to the date of the hearing. And like I said, most of her symptoms dealt with her feet. She had bone spurs. She had tendinitis. She had several symptoms dealing with her feet, and that's why the doctor prescribed several devices to help her to walk. And she got so bad, Your Honor, for the pain, he prescribed that she wear a boot, even when for 24/7, even when she was asleep, she had to wear a boot on her foot to help decrease the pain because the pain was getting worse over a period of time. And in his report, he indicated that she was not able to work because of that. She had to wear the boot 24/7 in order to deal with the pain. And that affected her ability to, for dealing with her mental impairments. She had, like I said, she had anxiety. She had depression, chronic depression. And she was diagnosed by her doctors with post-traumatic stress syndrome. She had problems with what they call DMS5, and like I said, the post-traumatic stress disorder was diagnosed in 2016, and he increased her medication because of that. And for the foot and ankle clinic, she was diagnosed with pain and she had a left Achilles tendinitis in both feet. And all of these diagnoses, as far as the tendinitis, the bone spurs, Achilles tendon, that's basically consistent with all her medical evidence since 2011. Almost all the doctors that she went to see and that who examined her, they mentioned pain and they contributed to Achilles tendon, bone spurs, and things like that. And she even had surgery, I think it was 2014, on her foot to help resolve the problem, but that didn't do it. And there was, he recommended she have additional surgery, but she couldn't because she didn't have any medical insurance to receive this type of treatment or surgery. So she's limited mentally because of depressed moods, and her depression caused her to be fatigued. She's socially withdrawals, and she also lacks the ability to concentrate. She has crying spells, and she has, and one of the doctors said that she met the criteria of Dr. Locklear for post-traumatic stress syndrome. And like I said, there's about half a dozen treating and examining physicians who basically came up with the same physical disabilities. The premier behavioral clinic was primarily treated her for her mental impairments that dealt with her depression and post-traumatic stress syndrome and things like that. And she had crying spells, which affected her
Mr.
ability.
Davis, you're about out of time. You saved some rebuttal time. You want to continue to save that rebuttal time?
Yes, sir.
All right. Why don't we hear from the counsel for the Social Security Administration? Is that all right?
Yes, sir. That's fine.
All right. Ms. Quick,
May
are
it
you
please
there?
Yes, I'm here.
Good to have you with us, Ms. Quick.
Thank you. My name is Jillian Quick, and I represent the Commissioner of Social Security. Your Honors, substantial evidence, as we were reminded in Bistek v. Berryhill, is not a high burden, is not a high standard. It is ultimately the plaintiff's burden of proving that she's disabled. And as long as there is sufficient evidence that a reasonable mind might accept as adequate to support a conclusion, then it should be upheld. Here, there is substantial evidence that bar is met exceedingly. This was a 39-year-old woman at the time of her application, at the time that she purportedly became disabled, and she was 42 years old at the time of the ALJ's decision. She purported that she was disabled because of foot impairments, including plantar fasciitis and bone spurs, as well as irritable bowel syndrome that caused constipation. Those were her main complaints. But with respect to her foot, she testified that she wore her shoes tight to put pressure on her feet. That's on pages 89 to 90. With respect to constipation, she took X-Lax periodically, and that's on page 77. She reported to a provider on page 733 that she had a fair treatment response using X-Lax and that the medication was adequate. She admitted at the hearing that she was able to stand for 1 hour and she could sit for as little as 30 minutes and stand again, despite her pain, and that would relieve her foot pain. And that's on pages 76, as well as pages 65 to 66. The ALJ limited her to jobs that allowed her to sit or stand as she needed. And that's in his decision on pages 46 to 47. The vocational expert testified that as long as she could remain in either position for at least 30 minutes, she could do the jobs that the vocational expert identified. And that's on pages 95 to 96. Further providing additional substantial evidence in support of the ALJ's decision is that the record shows that she did not need an assistive device to walk, like she did not need a cane, for example. She had a normal gait.
Were these jobs close to where she lived?
Your Honor, the requirement under the regulations is that the jobs exist in a significant number in the national or regional economy. So there is no requirement that they be within any particular commuting distance.
You didn't answer my question, though.
Okay, Your Honor, I do not believe the vocational expert testified as to the distance from her home.
Okay. So she lives where? You know where she lives?
Oh, yeah, I believe I did see that. She lives.
And where were the jobs that she was supposed to get?
In Lumberton, North Carolina.
That's where she lived?
Yes.
That's where she lives?
I believe that's her address on the ALJ's decision on page 39.
Okay, and where is she supposed to get these jobs?
Okay. The various jobs included hospital product assembler, inspector.
Where is she supposed to find? Where are they?
Well,
they're in the national economy somewhere. That's what you said?
that's correct. The vocational expert testified.
Where is she supposed to get it? Charlotte or Raleigh or someplace like that?
Your Honor, I am not familiar with the jobs that are available in her
Well, you're the one that
specific
brought
community.
it up. You're the one that brought it up.
Sure, Your Honor.
You said that the expert said she could find a job.
Yes, the ALJ asked the vocational expert to specify jobs that would be available.
Right.
And
available.
vocational.
The jobs are supposed to be available. There you go. There's a word. Available.
Yes, Your Honor.
All right. If it's available, 100 miles from where she lives, is it really available?
Okay, Your Honor, that is not the standard, and I believe that's in past.
I'm not asking you for the standard. I'm asking you if it's available in Raleigh, North Carolina, for example. That's about 100 miles maybe from Lumberton. Well, is it available to this lady?
Your Honor,
it's your position. Is it your position that's available to her? Is it the Social Security Administrator's position that's available to her?
Your Honor, step
you're
5.
Here representing the government, and you're telling us that she's got jobs available.
Yes, Your Honor.
That she can do. Well, all right.
Yes. Yes, Your Honor. This is a young individual who is limited to light work that allows for a sit-stand option. And the vocational expert testified that these are jobs that are available in significant numbers in the national economy. And that is all that the regulations require.
Okay.
It's like, for example, we don't consider your ability to get to work. We don't, if you have a limitation that you do not have a vehicle, for example, the commissioner does not consider that.
That's which makes no sense when you use the word available connected to it.
Well, you're okay.
They're available, but you don't consider whether the transportation. You don't consider how far it is. It's available in the national economy. So in your view and your client's view, it could be available in Atlanta or Cleveland or somewhere, and this lady wouldn't be entitled to benefits because it's available. I mean, I'm not arguing that's what the regulations say, but that doesn't make a lot of sense.
Right. I mean, the standard is just that the work exists in the
That's
national
right. It does
economy.
make a lot of sense. The standard is national economy.
Yes.
But the word available undercuts it.
Well, it's, Your Honor.
Available to me means it's something she could get to and do.
Okay.
And you're telling us that's not the government's position as to what availability means. It's available, but it's not available.
Your Honor, that is the standard, and it's maybe available is the wrong word for me to have used. Perhaps it's just whether it exists.
Regulations is available. That you said that was the testimony of this fellow that was the expert. I think you were referring to the expert. I wasn't.
Yes.
You were quoting the expert. I'm not blaming you. You were quoting the expert. He said it's available.
Well,
because as far as he's concerned, it's available in the national economy because that's what the regulations authorize him to say.
Your Honor, and I misspoke when I said that he said the vocational expert used the word available.
Right in the regulations, if that's what it says.
Right. The words in the regulations are that it exists in significant numbers in the national economy.
Okay. They don't have to be available. They just have to exist then. That's what your testimony is now, or your response is now?
Yes, Your Honor.
Okay.
And Your Honor, I hope I am answering all the questions, but if you need me to brief this further, because I don't believe we had an opportunity to address this particular issue. So I would be happy to provide something further. And, where I'm looking at is section 404.1566. We consider work that exists in the national economy when it exists in significant numbers, either in the region where you live or in several other regions of the country. It does not.
Region where she lives. So there you go.
And then it says, it does not matter whether 1, work exists in the immediate area in which you live, 2, a specific job vacancy exists for you, or 3, you would be hired if you applied for work.
Well, if she'd be hired if she applied for work, it would imply at least that it's something available to her that she could get to. If she lives in Lumberton, North Carolina, it would be something in the area around Lumberton that she could get in the automobile and drive to. It seems to me under that, I think it's the third alternative you gave us.
Okay, that it doesn't matter. It's saying it does not matter if you would actually be hired if you applied. So this is the standard for determining whether someone is disabled or not. It is not an actual exercise in providing them a job, for example, or ensuring that they would be able to get to the job. It is only to determine, are there some jobs that do exist in the national economy that a person with the claimant's limitations could perform. And in this case, the plaintiff was a younger individual, and younger individuals have more jobs typically available to them, especially in this case where she could perform light work that allowed a sit-stand option.
And she's younger than most of the applicants for disability benefits. That's fair to say, isn't it?
Yes, Your Honor.
Most of them probably in the 50s and 60s or so.
Right. Or, yeah, right.
Is
right.
she, something I didn't, is she overweight on this record? Is that something that's behind some of this? I didn't hear Mr. Davis.
I don't think she was diagnosed with obesity. I am actually trying to figure out her weight right now, but.
Okay, but I just, okay.
Right, right, given her.
That comes up in these types of cases sometimes with us. We hear a lot of these cases. We're not complete novices on the stuff.
Right. She did self-report her weight as 170 pounds. I'm looking at page 109. Mm-hmm. So, and 64 inches.
Counsel, can I ask a slightly different question? Just to make sure that I understand, and I'm particularly sort of asking about the concentration, persistence, and pace finding, where the district court indicated that there was a mild impairment. And I'm just trying to make sure I understand what is meant by mild. And this is not a trick question, so if you don't know, just say you don't know. But if I look at 404-1520A, it describes a 5-point scale, sort of severity of illness scale of none, mild, moderate, marked, extreme for CPP diagnosis. Am I looking in the right place to understand that? And then if so, can you point me to anywhere where there's an explanation of what those 5 stages mean?
Sure, Your Honor. Okay, yes, the district court did discuss the mild limitation and concentration, persistence, or pace on page 13, I believe, of the decision. Okay, yes, 404-1520A specifies the different levels, none to extreme. Mm-hmm. But mild is actually defined in like the listing 12.00 F2. And it says, you're functioning in this area, it says mild limitation. You're functioning in this area independently, appropriately, effectively, and on a sustained basis is slightly limited. By contrast, moderate limitation means you're functioning in this area independently, appropriately, effectively, and on a sustained basis is fair. If a person has no limitation in the 4 broad functional areas or only mild, that would actually demonstrate a non-severe impairment. A severe impairment requires at least one moderate. Here, she did have a moderate limitation in her social functioning, but not in concentration, persistence, or pace, which is what the district court found distinguished it from Mascio. And her main problem, she did describe, was dealing with other people. And that's on page 668, where she said that that was her main source of stress, was other people. And the ALJ then limited her to only occasional interaction with others. And Your Honors, she did not allege a mental impairment in her application. She didn't require any mental health treatment for 2 years after her alleged onset date. And the ALJ recognized that she initiated treatment towards the end of the relevant period and appropriately evaluated the records that showed prior to that time that she had an appropriate mood and affect, adequate judgment and insight. And then at her initial examination before she was on medication in August 2016, she had some difficulty spelling world backward, and recalling some items after 5 minutes. However, treatment notes thereafter in October and November showed that she had logical thought processes and she had goal-directed speech, and that's on pages 684 and 670. The ALJ limited her to simple routine tasks, even though there weren't any restrictions given to her by a treating provider.
I have one question, if I could, Ms. Quick. With regard to the evidence of sit-stand, did the ALJ's finding on RFC, the residual functional capacity, was it adequately reflected in the hypothetical? It seems to me there were differences in terms of what the hypothetical said and what the RFC said in the ALJ's finding. So how do we deal with that in analyzing this case?
Okay, Your Honor, I am out of time. Is that okay that I respond?
You go right ahead. If you got questions, you go ahead and answer them.
Thank you very much. Okay.
Yeah, you answer Judge Keenan's question the best you can.
All right, thank you so much. Okay, in the RFC, it says sitting or standing as desired, such as in bench work occupations. And that's on page 46.
Didn't it stand as needed someplace?
Okay, and then I'm not sure where the discrepancy is, so I'm trying to quickly look right now. I apologize.
No, that's okay. It's just that
okay.
I thought that it was more specific in the hypothetical.
Okay, let me see.
It was in the RFC, and my question is just, and I don't know the answer. I'm asking you.
Okay.
Problem here because of that.
Okay, I see on page 95, it says the individual would be able to perform the jobs either sitting or standing as desired, such as in bench work occupations. I believe that it says as desired, and then the RFC says also as desired, such as in bench work occupations. So pages 46 and 95 look identical. And it is consistent with her testimony where she testified that she could stand.
Can I follow up on that just for a second? I don't want to hijack Judge Keenan's question, but I thought in the hypothetical, the question was asked whether she could stand or sit for at least a half hour at a time. And that seems different from saying sit or stand as needed, because that would imply that you have a choice at every moment whether to sit or stand.
Your Honor, okay, the ALJ did ask about sitting and standing as desired. And then the vocational expert said, as long, and this is on pages 95 and it continues on to 96, it says, I do find that these jobs, someone does need to be able to maintain a position for approximately 30 minutes in order to stay productive on the job. So then the ALJ said, I believe she testified she could stand for about an hour and then would have to sit for about a half an hour. And then the vocational expert continued to describe the jobs. So the ALJ's question was as needed, and then the VE clarified that she would need to sit for 30 or stay in one position for at least 30 minutes. And the plaintiff testified that she could do that she would be able to stand for an hour and sit for 30 minutes and then resume standing. And that was on pages 76 and I believe it was earlier in her testimony as well on pages 65 to 66. She testified that she actually had tried to do that in her prior occupation, but she said that it slowed her down too much. However, here the vocational expert identified jobs where she would be able to be productive. They are different jobs, ones that she would be able to be productive at as long as she could just stay in either position for at least 30 minutes.
So the 30 minutes was used as the equivalent of as needed in that discussion.
Right. Yes, Your Honor, that's correct. Because
that seems to be probably inappropriate in the context of Judge Richardson's question.
Your Honor, she testified that that was how she needed to stand and sit. She testified that in her prior job that she did try to do this exact kind of sitting and standing, and that her employer did allow her to do it. But in that type of job, she wasn't able to be productive because it was not a bench work kind of job like the vocational expert was able to identify. And the vocational expert
What kind of surgery was it she needed? What was the surgery that she needed? For a couple of doctors did some surgery.
Right. Her ultimate surgery that she ended up getting after the ALJ's decision was for plantar fasciitis and tendinitis.
Is that what she was that she needed? There was some surgery that she needed a couple times, and she didn't have enough insurance didn't have insurance that would cover it, so she didn't get it. Right.
That is, it seems, the procedure that she needed. And she ended up getting it after, it was almost a year after the ALJ's decision. That's
is that in the record then?
Yeah, yes, it is. It's on page.
Well, how's it get in the record if it's after the ALJ's decision?
She submitted it to the appeals. Your Honor, I didn't mean to interrupt. She submitted it to the appeals council. So it's,
okay.
There's evidence of it. The prior to the surgery is on pages about 18 and 23, 34, and then post-op, there's a treatment note that was submitted on it's page 25. But Your Honor, the ALJ did account for her foot impairment, although she was not able to get this surgery that was recommended. She was not taking regular pain medication. Her only medication was X-Lax. She was not taking anything else, and she testified that she just wore her shoes tight to relieve the pressure. And the ALJ
at some point there, she was taking Tamarol, right? Somebody had her taking a dosage of Tamarol. That's a pain medication.
There was a time that she took some pain medication, Your Honor, and I'm not sure that was even during the relevant period. But as of the time of the hearing and in other treatment notes from 2016, she was not taking anything. And the ALJ, and she said she could stand.
Did get cut off from her medications because she didn't have any insurance?
Your Honor, she wasn't even taking a leave. And this is not a woman who is only getting treatment from a free clinic. She did actually see specialized providers, a variety of specialized providers. This is not a person who was going to the ER frequently because of pain. And she doesn't even have any restrictions given to her by any of her providers.
Mm-hmm.
She did testify she would be able to stand despite her foot pain. She could stand, and then she would be able to sit to alleviate the foot pain, and then she could stand again.
Is that all you have? We've given you some extra time. We appreciate it.
Thank you.
Let's Judge Richardson or Judge Keenan have something else they want to ask about.
No, thanks.
No.
Very good. Thank you, Ms. Quick. We appreciate it.
Thank you.
Mr. Davis, you still with us?
Mr. Davis, can you please press *6 to unmute yourself? I had to mute you from the Zoom conference. *6 will unmute you on your phone. Mr. Davis, if you press *6, you should be able to unmute yourself.
Are you there, Mr. Davis?
I'm sorry, Judge, I had to mute Mr. Davis. Thank you. Thank you. Mr. Davis? Mr. Davis?
what happened.
Is that you, Mr.
Mr. Davis, I can hear you.
Okay. Yes. Can you hear me
Mr.
now?
Davis, give us your rebuttal
Yes,
argument.
sir. Okay.
You got
Your Honor,
three-
basically,
3 minutes. Yeah.
okay. Your Honor, we think the evidence is not supportive of the ALJ's decision, both because it's not substantial and because of legal errors made. Like I said, in making the determining impairments and RLC, the ALJ did not properly weigh and evaluate the medical evidence from her treating physician. The only evidence he used in making his decision that I can determine, there wasn't any, because he signed a little weight to the evidence from the state agency. Now, that's important because he didn't use the function by function analysis in evaluating her limitations and restrictions on her ability to walk, stand, sit, push, and pull. He didn't do any of that analysis that's required by that, and that's one of the basic rules under the rules. And the cases all said that he's required to make a detailed discussion and findings on each of his conclusions dealing with how the restrictions and limitations affect her ability to walk, stand, sit, and push and pull. And he didn't do any of that discussion. And the judge said that was harmless error, both for that and for the error that the ALJ made in not weighing her medical evidence from her treating and examining physicians. And without those two, there's nothing else, no other evidence that he can base his decision on. He just based it on, looking at the record, you cannot tell what way he signed the what, because he's on the way the agency decision, he signed a little weight. Now, as far as the function by function analysis, that is the test, because you have to use that and determine the RFC, the functional capacity, what she can do or can't do. And that was not done. And so that's important based on Monroe, that for this court to determine whether or not you can make a meaningful review of the decision. And I'm contending that the court cannot, because this function by function test was not used in this case, nor was the proper standards used in weighing, assigning, and evaluating the treating physician evidence. And that is the case. He didn't use it in determining her RFC, functional capacity, nor did he use those limitation restrictions in the hypotheticals that he proposed to the vocational expert. So without all the evidence being considered and weighed and proposed to the VE, the evidence is insufficient, it's not substantial, and it's based on error. And that's my contention. So even the ALJ, the vocational expert, said that if she missed more than 10%, she'd be disabled. And based on her testimony, that sometimes she may miss days out of work because of the pain. And most of her pain, doctors rated her pain on a scale of 8 out of 10. And she had the word devices to walk, even to sleep, to help resolve her pain or relieve her pain. And it didn't do it completely. So even if she was able to stand, she was still in pain, like she said, in constant pain. She said, I can stand, and she said she could walk, but she's in constant pain, and that pain would affect her ability to concentrate and do things. And they all said that she had problems or her depression and being around other people, and that's what she testified to.
Mr.
So
Davis, do you hear that bell?
Yes, sir. I'm sorry. So I'm finished, Your Honor. I don't think the evidence supports.
Well, go ahead. I'll give you another 30 seconds to say something, finish up there, but make sure you heard the bell. I thought I heard the bell. Go ahead. Yeah, I heard. Like I was saying in summation, because he made an error with the treating physician and examining physician, and not weighing that, and in not doing a function by function analysis of her restrictions, the case cannot be supported by substantial evidence. And thank you, Judge. Thank you, Mr. Davis. We appreciate it, and we'll take your case under advisement. Now, if we were in Richmond, if you lawyers can still hear me, if we were in Richmond here in this case, we'd leave the bench, the 3 judges now, And we'd come down to the well of the court and greet you. And we would individually tell you that we appreciate your arguments and thank you for your work. But we're not in Richmond. We can't do that. We'll just have to, you'll have to accept this as the best we can do, maybe next year. And
Yes, hopefully.
Madam Clerk, we'll take this case under advisement and you can call the next case.
Yes, sir. The next case is David Balch versus Oracle Corporation.
That's good. Why don't you, you represent Mr. Balch, is that right?
I do.
You go right ahead and explain to us why he's entitled to relief here.
Thank you, Your Honor, and may it please the court. And I too regret that we're not in Richmond today. This is a strange format for arguing, but I will give it my best. The issue of the scope of deference accorded to an arbitrator under the Federal Arbitration Act is not new to this court. It's not new to common law. It flows out of the U.S. Code, Section 10A of 9 U.S.C. But this court, particularly Your Honor, Judge King, has dealt with the issue before in Patton versus Signature Insurance, a case that was cited in our brief. And ironically, in that case, the district court judge that did not vacate the arbitrator's award and prior to the Fourth Circuit then doing so was Judge Legg, who was the arbitrator in our case. And in the Patton case, as this court made clear, while there is broad deference to be accorded, it is not absolute deference. And among the several articulated reasons for vacating an arbitrator's award are two that form particular relevance here. One, if the award fails to draw its essence from the contract. Or two, if the award evidences a manifest disregard of the law. And the court looks at questions of law, as you know, de novo. So draws essence from the contract. What does that mean? That means, as this court explained, that the result is not rationally inferable from the contract. And here, as I'll get to shortly, the payment to Mr. Balch simply was not. Manifest disregard of the law means that the arbitrator understands and correctly states the law, but then proceeds to disregard it. Again, that comes from your opinion in Patton, Judge King. And here, arbitrator Legg did so by understanding and correctly stating the summary judgment standard under Federal Rule 56. In fact, going on to articulate that summary judgment.
Did the lawyers, did you all agree that this would be handled pursuant to principles of summary judgment?
Well, we agreed that the parties would submit motions for summary judgment, but we did not agree it would be resolved on summary judgment. We simply agreed that that would be part of the process here. Does that answer your question?
Did you? Well, is the arbitrator you all agree that he was a fact finder in the context of this case, like a bench trial?
Had there been a trial, he was the fact finder. But in other words,
right. Well, he found, like on this contract, that this cap was not in the contract, but it was missing because of a mistake or something, right?
Correct. He did make that finding, and respectful, I submit that was the manifest disregard of the law, and that finding did not draw its essence from the contract. And
well, he put the cap in the contract.
Correct. There was no dispute of material fact here that there is no cap written into the contract.
Okay, but Mr. Schwarber, what about the contractual provisions providing that the incentive compensation is not earned until there have been adjustments, modifications, changes for the purpose of addressing administrative error. And the arbitrator found that this was an administrative error. So I don't see how you can say there was a manifest disregard of the contract.
Well,
Considered the contract.
you
just don't like the result.
Respectfully, I understand your question, but I respectfully disagree. The arbitrator did two things, and he did consider the contract. He did two things. First, he said there are other reasons why Oracle can change a promised bonus, and those are summary judgment is too blunt an instrument to deal with those. And so he found that what he was going to look at only at the summary judgment stage, the only thing he agreed he could look at was this issue of correction of an administrative error. So he narrowed it to scrutiny of the correction of administrative error. But if you look at that in the context of what is an administrative error, and whether what Oracle did here was in fact correct an administrative error, that's where the manifest disregard of the law is. The mere fact that Oracle, I concede, Oracle retained for itself the discretion to correct an administrative error. If they promise Balch X and the contract writes Y as a typo, they can correct that. If they promise a particular formula and the computation of that formula comes out wrong, inaccurately, they can correct that. That's an administrative error.
Okay, but is there any evidence in the record to show that Oracle intended to omit the cap?
Yes, there is.
What is that evidence?
The starting point, I don't mean to be glib about this, but the starting point is the language of the contract, which doesn't have a cap. And then Oracle.
Did Oracle write the contract?
Oracle wrote the contract. Oracle drafted the contract.
Okay.
Yes, I'm sorry, Judge King. I didn't mean to interrupt you. Yes,
No, that's okay. It seems to me that you're now in a territory where the arbitrator has found that there was an administrative error. And the compensation agreement allows for correction of administrative error up until the time of payment. So it seems to me then you would have to be able to point to evidence in the record that the arbitrator disregarded, not the original omission of the cap that you're relying on, but actual evidence that this wasn't an administrative error. But you're saying, as I'm understanding you now, that it's sufficient simply to rest on the absence of a cap.
No, I'm sorry, I didn't mean to conclude there. Mm-hmm. The starting point is the absence of a cap. From there comes scrutiny that took just over a month, and we cited this throughout our briefs. It took just over a month of scrutiny with nearly a dozen Oracle people, including in particular Ed Screven, who ultimately had to approve the contract for signature by Oracle before it's presented to Mr. Balch. And Ed Screven, you may recall, is the same gentleman who ultimately applied the discretion at the end, which I'll get to in a second. But so multiple layers look at it, multiple realms of scrutiny look at it within Oracle. Specific questions are asked. Nicole Hoffman specifically, who's charged with looking at this, asks, was there supposed to be a cap in here? She specifically asks, if there was supposed to be a cap, we have to alert people. Jin O is another gentleman who's looking at it, and he specifically says, and this is at page 206 of the record, quote, for Dave, his plan does not have a cap, so any reduction would have to be via discretion.
Okay, but wasn't there evidence of a template error?
There was testimony.
Can you tell us about that? There was an evidence that there was a template error that affected more than just Mr. Balch's contract.
Yes, and the way this plays out, and the reason why I suggest it's inappropriate for summary disposition, is all of the contemporaneous documentary evidence, which is not only the contract, but internal emails at Oracle that we obtained through discovery and that are all provided in our record, show that the cap not only was not in Mr. Balch's contract, but there is no mention of a template error. There is specific inquiry, why is there not a cap? And there is an explanation provided contemporaneously that Mr. Balch is what's called an EVP -2. So there's EVP, which is Executive Vice President, and the way Oracle's staging works, there's EVP -1, who reports to the EVP, and then there's EVP -2, which is Mr. Balch's level. And there's a document that says.
Robert, I guess maybe what maybe I haven't been specific enough, or maybe I haven't been I don't know, precise enough. But it seems to me that you're in kind of an awkward position here, because you were moving for summary judgment, and now you're here telling us that that you were denied the opportunity to cross-examine on disputed facts. So what are we supposed to do with that?
Here's the answer to that one, Your Honor. And ours is not the first case to have that situation, but as we argued in our summary judgment papers, as well as in our opposition to the Oracle summary judgment, both of which are part of this record, if Judge Legg had granted us summary judgment in arbitration, and we didn't appeal his denial of our summary judgment, but had he granted us summary judgment, it would be because the four corners of the contract are clear and unambiguous. And what we argued is basic contract principles that, based on a clear and unambiguous contract that contains no cap and has a built-in promise of a compensation formula uncapped, we should prevail on our motion for summary judgment. We simultaneously said Oracle's position is not that the contract contains a cap, but that the contract needs to be read to have inadvertently omitted a cap, that this has to be determined to be an administrative error. And so Counsel, that requires—
Can I ask a separate question? Because you cite to the email at 205 and 206 as, and I took it that you were citing it as contemporary evidence that they thought about this before, and so it wasn't an administrative error. But that email comes after the deal is signed, right? That email to me seems to suggest, or at least reasonably could be read to suggest, that of course this was an administrative error, because they look at it and say, holy cow, there's no cap here. Shouldn't there been one? Right? That's after the fact. That post hoc discussion is not evidence, as you suggested, that this scrutiny leading up to the signing of it was somehow not an administrative error.
There was post hoc discussion. They're kind of—
That's what you gave us, right? In trying to tell us what the evidence before was, what you gave us was post hoc discussion.
I gave post hoc and pre hoc, if that's such a term. The discussion contemporaneous with preparation by Oracle of its contract to submit to Mr. Balch included scrutiny by the very groups that would have imposed a cap or put in a cap. It included scrutiny and there was evidence of this in the record. Multiple reviewers.
But the sites you give us to at least Ho, you didn't give us a page site for Hoffman. Those are both post hoc, right? And so those don't actually support you, do they?
They do support me, Your Honor, respectfully.
But are they post hoc? Answer that question first.
Yes, they're post hoc, but
I understand that. Can I ask a different question though?
Sure.
So you started when Judge Keenan asked you about this, and you said, he called this administrative error, but there was a question of what that is, and was this one? Those were the two questions you said. What are we looking at? So the arbitrator determined that this was administrative error. Is there a definition section in the contract? Tell me what I'm looking at to say that is like not plausibly a reading of administrative error such that it was an unmistakable one by the arbitrator. What am I looking at? What contractual language? Am I looking at Black's Law Dictionary? Tell me what I'm looking at to show that that's an unmistakable legal error.
The answer, Your Honor, is I can't point you to a provision in the contract because there isn't a definition of administrative error within the contract. What I can point you to is what the purported correction was. What arbitrator Legg decided was the correction was payment to Mr. Balch of what would have been 303% of his quota. And that 303% is explained post facto by saying, oh, there should have been a 250% of his quota cap in the contract. So this is really that plus an additional 50+%, which is $50,000 and change, additional that I, Ed Screven, will explain my decision to do by saying, oh, I decided to give him essentially a tip because we took too long to pay him. That defies credulity.
This is another example of saying the post hoc discussion you think makes it unmistakable error that ex ante this was not an administrative error, but instead was a conscious decision.
I'm saying the post hoc discussion is all we have. There is no communication
that's
prior.
What I thought. I just wanted to make sure. Thank you. I didn't mean to take you so far over time. Thank you, Judge King.
That's fine. I will. I haven't talked about the Wage Act, but I will come back on rebuttal time and bring that in if I may.
Let me ask you one question because I want to ask your colleague there when he gets up. Why is it that everything in this arbitration proceeding is sealed?
There were it's not everything, but there's certain
on the
numbers.
Sealed on the joint motion.
The contract.
You are using the federal court and sealing up all the papers. We're supposed to be open to the public, transparent.
And Your Honor, I don't mean to dump this on Mr. Kinnaird, but the contract is a government contract that Oracle has, and Oracle has certain security concerns about it. So we agreed to their suggestion that it be sealed.
Just the contract was sealed.
Well, information about this particular contract has been sealed. That again is an Oracle issue. It's not Mr. Balch's issue.
It's not, is it claimed to be like a military secret or top classified or something?
I would respectfully defer to Mr. Kinnaird to answer that one.
Well, you're the only one I got standing here now, so I threw them on there.
Oracle believes that there is some classification associated with this contract that required the sealing of some specific identifying information. I can't answer it better than that. I just don't know.
Okay, and you all stipulated that it could be sealed.
Yes.
And the district judge went along with it.
That's correct.
There's no record made other than that.
That's correct.
Okay.
All right. If I may save, I'll save.
You got rebuttal time. Yeah.
Thank you.
Mr. Kinnaird.
Thank you, Your Honor. May it please the court, Stephen Kinnaird for Oracle. Mr. Balch cannot meet the exacting standards for judicial vacator of arbitration awards, which are among the narrowest known in law. Balch's first claim of manifest disregard of the law of summary judgment is waived because he did not raise it below, which is why the district court made no findings on this score for this court to review. Regardless, his challenge fails. And while I'm happy to discuss whether, or the reasons why Judge Legg correctly found there is no genuine issue of fact, I would emphasize that is not the standard that Balch must meet. To prove manifest disregard of the law, Balch must prove that Judge Legg identified a clearly defined and applicable rule of law and then chose to ignore it in propounding his decision. That's, this court said in Remy and 3S. This is a willfulness standard. So it's not, and that's the difference from an appeal from a summary judgment. Courts have required it, characterized it as requiring a willful flouting of the law that is recognized by the arbitrator.
More basic than that, Mr. Kinnaird, on summary judgment, when you grant a motion for summary judgment, when a court does, I always understood like they're going to give Oracle summary judgment. You have to give the facts to the other side.
That's
you have
correct.
to view in the light most favorable to the other side. And in the light most favorable to the other side, you'd have to take that contract as it's written.
That's correct, Your Honor, and he did that.
And that was not done here. So summary judgment, Rule 56, that principle of summary judgment certainly wasn't complied with and at all.
Well, Your Honor, again, the standard is whether he chose to flout it rather than.
You combined a bench trial with the summary judgment principle and got a judgment. I guess you can do that in arbitration. I guess that's what your position is. You can probably do that in arbitration. You can do about anything you want and get away with it.
No, Your Honor, that's not our position. I think he correctly applied Rule 56, and you can see that. And it's
in the light most favorable to the plaintiff. He did not do that.
Well, Your Honor, I would respectfully disagree, and if I may explain. So there are two options here. The one is the omission of a cap an administrative error, or did Oracle intend to grant Mr. Balch an uncapped plan as an exception to the generally applicable policy for other EVB2s? And there is simply no evidence of that whatsoever. He was not, the arbitrator found, and this is based on Balch's admissions, he was not promised an uncapped plan. There's no evidence of any discussion or request for, a directive for it to be an uncapped plan. And in fact, it's obvious from what happened, and you can see these from the emails at 548 to 50. What happened, his plan was simply generated from the template, and it was determined that that template was an error. So there's no evidence whatsoever as to a cap. And that and the emails that he points to in the discussion between Ms. Dyer and Ms. Hoffman and Mr. Larson, and those would be at A739 to 740, the question posed by Ms. Hoffman, is this intentional? Because there are only a couple of folks here without caps, which shows that there was a policy. And then Ms. Dyer looks at the template and she says, I'm seeing that the template is only for EVP directs. And then she said, is the cap not supposed to apply to the people who are not EVP directs? And then Mr. Larson simply replies by pointing to the template and says the cap language would only come into effect with EVP direct. And so when it was investigated, it was determined that that was an error. So there is no evidence that suggests the possibility of an intended exception that would give him an uncapped plan. And all that he can point to is the fact of the face of his contract, and that could be either by error or by intent. But that there is nothing. Once he had 4 sworn deponents all testify that it was error, there was nothing else.
Hey, Mr. Canaroff, I have a question regarding page 11, Schwaber's brief. He says that Balch was paid in the first and second quarters of 2015, an uncapped bonus amount. And is this discussed by any of the Oracle employees in their testimony?
It was discussed by Ms. Hoffman, the administrator, and I think that's a little misleading. One of the bonuses, the revenue attainment bonus, is paid as the revenue is booked. And so you get what under the contract are advances on the bonus. So for the revenue that was booked, he would get advances on that, but those amounts were well below the cap. And therefore the question didn't even arise as to whether, to apply the cap or not, because these numbers were so far under the cap. So, Your Honor, I think that there's no question that the contract, and I believe Judge Keenan adverted to this, the contract specifically gives the authority for Oracle to correct administrative error before it pays bonuses. And the contract of 567 says that employees are not guaranteed commission or bonus payments, and there's nothing earned until there's a final management decision. So we had no contract right to it, and there was really no genuine issue as to whether there was an administrative error or not. But Judge King, I would submit, again, that might have been the standard if this were coming up for appeal. One might say, well, he made an error. He just didn't apply the Rule 56 standards. But that's something different from what is needed to vacate an arbitration award. Because as this court has said, the parties have agreed to the resolution of the facts and the law by the arbitrator. So it's only if he doesn't do his job. He has to have willfully decided, I'm just not going to apply Rule 56. And if you look at Appendix 748.
Would it matter? Sorry, I don't want to distract you, but would it matter if your opponent had argued before the arbitrator that summary judgment was not appropriate as opposed to submitting a summary judgment brief of their own?
I think it does show both parties thought they could get summary judgment. He did oppose summary judgment on this issue. So I think this court can take that into account. But what I was saying is I think you have to look, if you see when he says, for example, at 757, after reviewing all the evidence, he says, all the consistent testimony on administrative error is, quote, uncontradicted by evidence that could persuade a reasonable fact finder of the opposite. And then he concludes, 763, no material dispute exists concerning these facts of administrative error. So he is not choosing to ignore Rule 56. He is not willfully flouting Rule 56. If you disagree with us that he properly applied Rule 56, that still is not grounds for vacator. This is not an appeal of summary judgment. Your Honor, I would like to turn now to the Maryland wage payment and collection law issue. Judge Legg also did not choose to disregard or ignore a clearly defined legal rule under the Maryland wage law. He identified the statutory language in Appendix 763. He analyzed in depth the precedent and the rules therefrom at 763 to 69, including the Maryland Court of Appeals decision in MedX. He addressed the highly distinguishable Hausfeld case and concluded that it was wrongly decided. And contrary to Balch's claim, Hausfeld was not binding precedent. A federal district court decision on state law is never binding. It is at most persuasive. And Judge Legg then applied the principles of Maryland law at Appendix 767 to find that the plan bonus was not a promised wage. And he specifically stated at 770 that he would follow the interpretation of Maryland wage law that this court gave in Varghese and the federal district court gave in Sorensen. So such findings foreclose a conclusion of manifest disregard of the law. And therefore, the district court did not commit clear error in finding that he identified the controlling principles, identified and resolved an ambiguity, and then heeded the legal principles he perceived to be correct and on point. And so again, Balch is contesting Judge Legg's interpretation and application of state law, which is not cognizable under the FAA. That alone should dispose of this issue on appeal, but Judge Legg also correctly analyzed the statute. The statute, as both this court and the Maryland Court of Appeals have held, treats a bonus as a wage only if it is both promise for service and if all conditions are fulfilled, such that it is due. And employee performance is only one such condition. And as this court held in Varghese, the employee must be not only entitled by promise to the bonus, he must be entitled by promise to the bonus, not merely eligible. And that's not the case here. I've already mentioned that the contract says bonuses are not guaranteed. It grants discretion as to pay terms and conditions at any time prior to final grant of a bonus. MedX is not to the contrary. It addressed a different question. The Court of Appeals there held that a definite bonus for work that the employee had already performed, and the wage cannot be withheld from terminated employees, even if the contract so provides. And the reason, and there's no comparable provision operative here, is that the statute expressly required payment after termination. Hausfeld merely extended that holding to a contract provision that withheld a definite bonus, 5% of annual production, from terminated employees at the employer's discretion. So MedX actually supports the court's decision in Varghese and the arbitrator's decision here, which derives not only from MedX, but the prior decision in Whiting-Turner by the Maryland Court of Appeals. And that holds that where a bonus is not promised, but is subject to discretion as to a payment and amount, there is no wage, much less a wage that is due. And on the third claim, Your Honor, Balch's challenge to the award as failing to draw its essence from the contract fails. This too is an exceedingly narrow standard, applies only when the result is not rationally inferable from the contract. This court has held that the standard is not error, but ultra vires action, just like with manifest disregard of the law. So if the arbitrator was even arguably construing the contract, the award must be upheld. And for all the reasons I've given, Oracle had full power to adjust a contract for administrative error, and nothing prevented in that adjustment for it to increase the cap by 50% of Balch's annual target variable. So as the district court held at Appendix 439 to 440, Balch's challenge simply ignores the express terms of the contract, and there's nothing to suggest that the arbitrator disregarded, modified, or even misinterpreted the contract. Now, my colleague began with the patent decision. That's very distinguishable. That is a case in which there was an arbitration agreement that had no statute of limitations, and the arbitrator imported from an earlier arbitration agreement a one-year statute of limitations and disregarded that the contract specifically said that all prior agreements were superseded. And if he'd applied Massachusetts law as this new arbitration agreement required, then the claim would have been timely. So that is one where there was effectively a rewriting of the contract, which is not present here. And Your Honor, just addressing a few points on the question about whether there was a template error, I think that's basically undisputed. Mr. Oates discussed that in his testimony. District court relied on that. And you see that the only genesis of the lack of the cap was by application of the template. And as I discussed, Ms. Larson and Ms. Dyer and Mr. Larson only addressed the functioning of the template. And it was later discovered that what had happened, and then the decision was made among the authorities, Mr. Screven and Ms. Katz, that they would correct the administrative error, apply the cap, and then augment the cap by 50% of the annual target variable. As far as the definition of administrative error, Your Honor, that is actually part of the contract. You will note it's Appendix 646, and it includes plan elements and formulas. So there's no doubt that this is the kind of administrative error that was contemplated, and it can certainly be unilateral. It does not have to be a mutual mistake as under contract law. So we think that that the arbitrator correctly applied Rule 56 and the Maryland wage law, but even if he didn't, one cannot, I think, fairly determine that he willfully flouted Rule 56. I don't believe Judge Legg did that. It's a very demanding standard for vacator. If there are no more questions, Your Honor.
I ask about sealing all the record here. What you didn't say anything about that.
Your Honor, I wasn't involved earlier, and I apologize. I hadn't anticipated that question. I would defer Mr. Schwaber's explanation. Seems correct. I mean, my understanding, the joint appendix has a confidential version, but also a non-confidential version, and it's primarily payout amounts. That it doesn't seem that much of the record is.
But the general proposition, proceedings in the federal courts are in public.
That's true, yes.
Food filings, and we have stringent requirements before we seal everything up. I mean, you all agreed to it all, and the judge signed off.
I understand that to be correct, Your Honor.
But I mean, we had a judicial conference a few years back, and we talked about the need for transparency in the courts.
Yes, Your Honor.
And that's what I'm thinking about when I ask that question.
I understand this concern, Your Honor.
That's fine. Good. I appreciate your work.
Thank you.
Mr. Schwaber, I mispronounced your name. I probably did.
No, you got it right. It's Mr. Schwaber. Thank you. The contract, the absence of a cap in the contract, that's the contract that Mr. Balch agreed to. There is no evidence whatsoever in this record that Mr. Balch ever agreed to a capped contract in his 2015 plan. It is beyond dispute that he never agreed to a capped contract in 2015. So what Oracle is suggesting that is within the arbitrator's discretion and is not arbitrary or capricious, because the decision, their discretion cannot be exercised in a manner that is arbitrary or capricious, as Oracle concedes and as arbitrator Legg said, is that Oracle unilaterally, after giving an uncapped contract and after Mr. Balch has done everything he was required to do, and the evidence is he did it well, he performed his job, the money was earned by Oracle, the largest contract in Oracle's history. After all of that, and after his work is done, which is what MEDEX says implicates the Wage Act, then Oracle, in correcting an administrative error, under the guise of correcting an administrative error, can decide at that point, well, let's just change the number. Let's use Mr. Screven's personal whim to do so. He'll decide, well, let's take this number, it'll be the cap plus. We'll call it the cap plus, and we'll call that an administrative error without any prior indication of error, without any communication whatsoever to Mr. Balch of error. That is the definition of arbitrary and capricious. And to do that at summary judgment, when every inference is to be taken in a light most favorable to Mr. Balch, when every factual discrepancy is to be taken in a light most favorable to Mr. Balch, that is the manifest disregard of the law here. And as this court said, and it's the Jacobs versus North Carolina Administrative Office of the Courts case that we cited in our papers, and Judge King, you were part of that decision. Principles of summary judgment are violated when a fact finder, quote, fails to credit evidence that contradicts some of its key factual conclusions. In this case, arbitrator Legg could not reach his conclusion without making factual findings about credibility, about the subjective determinations. He ignored clearly conflicting evidence. He dismissed it in his opinion as, quote, confusion that was subsequently clarified. The record evidences a desire, for example, to link Mr. Balch's payment to other team members on this government contracts team, to come up with this 53% formulation that Mr. Screven wanted everybody to get because he thought different people on the team shouldn't get different percentages associated with their plans. It evidences modeling that show Mr. Dodson, who's Mr. Balch's boss, who clearly did have a cap. It showed modeling that makes clear in their internal modeling that Mr. Dodson has a cap, that Mr. Balch has no cap, and that Mr. Dodson's cap should be exceeded so that he could get the uncapped amount as well. That's all internal. That evidence may or may not carry the day at trial, but they're in a light most favorable to the non-movement. it clearly is presented as evidence that needed to be considered here if Rule 56 is going to be followed. I only have less than 3 minutes left, so I will briefly turn to the Wage Act. The Hausfeld case, which I had the privilege of handling at the trial court, was acknowledged by Judge Legg, but then disregarded. And I agree with counsel that that can be looked at, but it is not binding precedent as a trial decision. The MedX case, which articulates the public policy rationale behind the Wage Act, as does Hausfeld, makes clear, and Judge Chang said it best in Hausfeld when he said, quote, contractual language between the parties cannot be used to eliminate the requirement and public policy that employees have a right to be compensated for their efforts. That is the purpose of the very purpose of the Wage Act. And we get into a very dangerous paradigm if an employer can, in its contracts, compel arbitration, promise what amounts to an apocryphal wage, reserve for itself some discretion to correct administrative errors defined in whatever fashion to correction of the administrative error specifically, exact performance from their employee, have him finish his performance, then fail to pay that wage, and enjoy a complete escape from judicial scrutiny because of deference to be accorded to an arbitrator. That can't be the law. Otherwise, there would be no judicial review. So the notion that this court set forth in the patent case, and that other courts have set forth is there is judicial review of an arbitrator's decision and of an arbitrator's discretion. And this 300+% of Mr. Balch's quota that was paid to him, it finds no rational relationship to the contract. It finds no rational relationship to the cap had it been in the contract. It's a completely different number. And so the only explanation for it requires an assessment by this arbitrator of credibility of Mr. Screven, who says, oh, well, it's the cap plus, and this is how I did it, and this is why I did it at the end, and this is why all 12 of us missed it previously. That is precisely what cannot be done in consistent with the mandates of Rule 56. And for those reasons, we ask that this court vacate the award.
Thank you very much, sir. We appreciate the arguments of counsel. Both of you done a fine job. And if we were in Richmond, we would leave the bench and shake your hands. So we have to do that remotely today.
Well, thank you. Thank you very much.
We'll do better next year, hopefully. Madam Clerk, we'll take this case under advisement unless
U.S. versus Miller.
U.S. versus Miller, number 204075. Ms. Akawa?
Good afternoon.
Akwara.
Yes, Your Honor. Good afternoon. Chiege Kalu Akwara for Mr. Miller, and I practice in Charlotte within the Western District of North Carolina.
Good to have you with us. Thank you.
Thank you so much. Your Honor, Mr. Miller pled guilty without a plea agreement to one count of possession of a firearm by a felon. The pre-sentence report was prepared. He filed certain objections to it. Some were sustained and the government withdrew a particular enhancement. The case before this court is whether the district court was correct in assigning one criminal history point to Mr. Miller, which bumped him up from prior record level 5 to a prior record level 6. The difference was, instead of having a sentencing range of 40 6 to 57 months. His range was, I believe, 51 to 63 months. The court imposed the highest offense possible under the incorrect criminal history category of 63 months. Mr. Miller pled guilty to and received a PJC, a prior for judgment continued for a marijuana conviction. There were no conditions attached. He wasn't required to be on good behavior. He wasn't required to do anything. It was not a diversionary judgment. The court just imposed a PJC and Mr. Miller went on his way. Under both Fourth Circuit law as well as law from the state of North Carolina, the PJC should not have counted for points. When you look at the assignment of points under the guidelines, the way the guidelines operate is under 4A1.1, the court assigns 3 criminal history points for each prior sentence of imprisonment exceeding 1 year and 1 month. We know that was not the case here. Add 2 points for each prior sentence of imprisonment of at least 60 days, not counted in A. Didn't apply here. Add 1 point for each prior sentence not counted in A or B, up to a total of 4 points. Wasn't counted here. Then under 4A1.1E, add 1 point for each prior sentence resulting from a conviction of a crime of violence that did not receive any points under A, B, or C above, because such sentence was treated as a single sentence. Your Honor, the issue here, it is true that Mr. Miller pled guilty. No sentence was imposed. A PJC, yes, Your Honor.
Ms. O'Connell, my concern is the North Carolina case law that seems to suggest that once you've entered a plea of guilty, that counts as a conviction of the offense charged. I think there's the Sidbury case, the State versus Canales. It seems to me that you've got a little bit of an uphill battle here.
Yeah, sorry.
How do you get around the State versus Canales that says that the defendant's prayer for judgment continued, and that was an assault case, is a prior conviction for sentencing purposes under North Carolina law? And then if you apply it to our sentencing guidelines, how is that not a conviction for what we have to count today?
Your Honor, as I cited in my brief, under the this circuit, your circuit has already held that a PJC, and I know it was in an immigration context, Gonzalez versus Sessions, where he even received $100 fine and a PJC, and they say it doesn't count for a conviction. The issue here is not whether it's a conviction. The issue is what sentence was imposed. I know the government cited an unpublished opinion by this circuit that says a diversionary purpose, a US v. Gonzalez, is a conviction, but there was no diversion. I went on the website, both the local website, I believe it was the Middle District, as well as the Fourth Circuit. I couldn't see what it is.
I see. So let me just make sure I'm getting this then. So what you're saying is, since the sentencing guidelines talks about a prior sentence rather than a prior conviction, you prevailed because there was no sentence.
That is correct, Your Honor. And if you look at the appendix, page 127, which is the sealed, the joint appendix, which is the pre-sentence report, based on the objection that I filed, the probation officer's response was 1 point, the defendant pled guilty to and was convicted of possession of marijuana and received a PJC on January 22, 2014. Pursuant to US SG 4A1.1 and comment 3, 1 point is added for each prior sentence counted under 4A1.1. But there was no sentence, because if you go to paragraph 41, which is where the conviction is, all it says is prayer for judgment continued. It is not a, it's not a judgment, and the way not.
Counsel, can you help me? You made a point, and I want to try to follow up on it a little bit. Under 4A1.2F, whatever we think a sentence means, the guidelines tells us that it includes a diversionary disposition, and independent of whatever North Carolina treats it. But when I look at what a PJC is and our discussions of it and North Carolina's discussions of it, it looks to me to be precisely what a diversionary disposition is, as indicated by our case in Bagari, which is a 1993 decision where we're looking at a Maryland statute, but that does very similar. It sort of kicks the can down the road, and we hold there that that's a diversionary disposition. Why is a PJC not a diversionary disposition under 4A 1.2F?
Because diversion from a judicial process under 4A 1.2F, which I also cited on page 10 of my report, is without a finding of guilt. And it gives the example of deferred prosecution. Those are the diversionary provisions in North Carolina.
No, that's the first sentence says diversion without a finding of guilt is not counted, right? So that's fair. But then it says a diversionary disposition resulting from a finding or admission of guilt is a prior sentence. So the sentence there says that a finding of guilt, which we have here, plus a diversionary disposition, that is kick the can down the road, which is sort of my layman's term for what a diversionary disposition is, that it qualifies as a prior sentence under federal law. And what I'm trying to understand is, why do you contend that a PJC is not a, quote, diversionary disposition resulting from a finding or admission of guilt?
With due respect, Your Honor, it is a finding of guilt, but it's not counted. You have to go by North Carolina law. The U.S. Supreme Court has said, in construing a state statute, a federal court may not interpret the state statute different. Johnson v. Fankel, Fankel, 520 U.S.
Wait, I want to understand. Let me just back you up a second. Do you agree that if we apply the guidelines provision 4A2.1F, the federal law, that it is a diversionary disposition, but that instead we must look to state law instead, and that leads us to a different result? Is that the argument?
It is the argument, Your Honor, because when federal law, when you apply sentencing, and I'm going to go by Simmons, when this court changed the meaning of Simmons in determining what a felony conviction is, this court looked to North Carolina to see what is a felony conviction. In some states,
the reason, just so I just want to understand that that's different because Section 921 of Title 18 directs specifically that the federal court looks to the law of the state of conviction to determine it's a conviction. But our law tells us explicitly that when we apply the guidelines, we apply federal law, not state law, in doing that. And the guidelines here tell us a diversionary disposition after a finding of guilt is a prior sentence. I mean, I'm sort of with you. I'm not sure why that is, but that's what it says. And that's what I think I have to apply. I understand your argument is that ignore this and look to state law. But if I don't do that, do you have an argument under subsection F that you don't meet the federal law definition of a prior sentence? Because
a diversionary sentence is a sentence where do some things and then the case will be dismissed, whether it's drug treatment.
But Ms. Okwara, the guideline says diversionary disposition. It doesn't say diversionary sentence, as I understand it, subsection F.
But this was not a diversionary disposition. It wasn't a diversionary.
Help us then. Why isn't it a diversionary disposition?
Because first is a prayer for judgment continued. Usually prayer for judgment continues include, as I cited in my brief, be on good behavior, participate in drug treatment. If you do all of these, we may not end up punishment. Some of the cases I cited says, if you're ordered to pay a fine or court costs, or you have to do other things, then it amounts to a judgment. This one, Mr. Miller pled guilty. He didn't even receive the suspended sentence. Prayer for judgment continued, go on your merry way. There was nothing to do. So there clearly wasn't a sentence.
I'm sorry, I don't mean to interrupt, but it's hard to tell when your sentence was ending there.
Right.
if it's a diversionary disposition, you're diverting from what? In other words, you seem to, is it a diversion from a conviction? Or
I'll give you an example. I represented somebody who pled guilty to a bunch of felonies, breaking and entering, etc. She pled guilty in June. She's going to do a deferred prosecution, or what we now call a 1996. If she doesn't enter any trouble for the next 2 years, even though she's pled guilty, the court didn't suspend any sentence, just cooperate with your probation officer. We'll come back to court. The court will dismiss the case. This is not the case.
So it's a diversion from a conviction, right?
In her case, correct.
Okay, well, why don't we have a diversion from a conviction here? It's just that it's unstructured. Your client on the burglary was structured. This is not.
It's not a diversion because she was not required to do anything. He was not required to do anything. He entered a plea. The case was over. Nothing. Some of the cases I cited is a prayer for judgment is not a final judgment when only court costs are imposed under North Carolina General Statute. Then
well, it's a prayer for judgment continued. The word continued has to be added on there. Prayer for judgment continued. It seems to me like it fits right in there with a diversionary disposition.
But the difference is no conditions were imposed. Mr. Miller was not required to do anything. All he did, for whatever reason, enter his plea and go on his merry way.
He wasn't required to go straight. He was trying to stay out of trouble, wasn't he?
He was not required to do anything, Your Honor. That's my argument. He was not required to do anything. He wasn't required to participate in drug treatment. He wasn't required to stay out of trouble. He wasn't required not to pick up any new charges, which is what diversionary programs in North Carolina require you to do.
Ms. Okwara, would there have been any consequences, for example, if he had distributed marijuana, let's say a week after he got this prayer for judgment continued? Would there
not on the facts that we have before us? And I'll give the court an example. Sometimes if you're driving, you get a PJC. You know, if you pick up another one, if there's no condition, if it doesn't say, don't do this, do that, they can come back and reopen the judgment. So this case was closed. If it says participate in drug treatment, and if you complete it, then we'll dismiss the case. Then that is a condition, which if he didn't do the drug treatment, judgment would be entered. Mr. Miller pled guilty to possession of marijuana, a class 3 misdemeanor, and was allowed to go on his way. In today's case, he wouldn't even be entitled to counsel because it's a class 3 misdemeanor.
Okay, so you're saying that in the prayer for judgment continued, here there was nothing continued. So it wasn't really a prayer for judgment continued because nothing was continued. He just walked away with no conditions.
I guess the way we explain this is when a judgment is continued, then eventually the state can come and pray judgment and say, Your Honor, what's the court to pray judgment now? Let's say you have a cooperating witness. A witness has cooperated, so we now pray judgment. So there was no judgment was continued, it wasn't entered. And that's why I cited some cases that say it is not a final judgment. It's not because nothing was entered. Mr. Miller was not required to do anything, not pay a fine, not stay out of trouble, absolutely no condition.
But counsel, whatever Mr. Miller did, what you just said, I think, is that either the prosecutor or the judge can then call for a judgment at any later time and impose a sentence.
Not in this case.
For any reason or no reason. So why not in this case? Because when I read 14-404, which is the statute under which the PJC is imposed, the continued is in the statute, right? The point of the word continued is not that it is ended. It's not a prayer for judgment never to happen again. It's a prayer for judgment continued.
Your Honor, with due respect, the case is over unless there are conditions. And that's what I cited, gave examples in my brief on page 21. If it just says court costs, you can bring him back. If it says be on good behavior, if you say all that, there's no reason to haul Mr. Miller back into court. The case was closed, and Mr. Miller would not have had a right to appeal because it's not a final judgment under North Carolina law. He couldn't have said, Your Honor, I don't like the judgment, I want to appeal. He wouldn't have authority to. He would ask the court judge, enter judgment so that I can appeal it. That's why they don't count it as a final judgment. And I gave the example of the North Carolina Supreme Court case in State v. Griffin. I believe it's a 1957 case. He was not required to do anything. So it wasn't a sentence, it wasn't a final judgment under North Carolina law. And you have to go by what North Carolina law hears. And even this court, US Supreme Court has held, in reviewing a statute of conviction in question, the court consults the law that applied at the time of conviction. McNeil versus United States, 563 US 816, a 2011 case. And the Second Circuit also adopted in Rivera versus United States, 716 F3rd 685, a Second Circuit case. The case cited by the government is an unpublished decision. I've cited to you published decisions, both Gonzalez v. Sessions, as well as other cases saying PJC without more.
But it's an unpublished decision by this court. It's what we have said before. We can take it into account. It used to be we couldn't, but anymore we can take that into account. And I think we not only have Gonzalez, we got a couple more on the same point.
And I get both from the state as well as the Fourth Circuit. Mr. Miller was not required to do anything. It's not a final judgment. Prayer for judgment continued. Probation officer got it wrong. It says a sentence was imposed. We know a sentence wasn't imposed. The government brings
I think we understand your position. You've stated it more than once. I think we understand your position. Let's see what the assistant U.S. attorney says. You have some rebuttal time too.
Thank you, Your Honor.
Thank you very much. Mr. Enright?
Thank you, Your Honor. May it please the court, Anthony Enright for the United States. The district court properly assigned one criminal history point to Miller's 2013 North Carolina marijuana offense that resulted in a prayer for judgment continued. This court was correct in United States versus Gonzalez when it held squarely that a prayer for judgment continued under North Carolina law is a diversionary disposition resulting from a finding or admission of guilt that is awarded 1 point under section 4A 1.1c of the guidelines. It's basically a quote of 4A, I'm quoting this court, quoting 4A 1.2f, which specifically says that a diversionary, it defines the term prior sentence, that's a term that's defined by federal law, to include a diversionary disposition. A disposition may not be a sentence in the colloquial sense, but the Sentencing Commission chose to define it to include any disposition, any diversionary disposition resulting from a finding or admission of guilt. And that's the hallmark of...
Gonzalez, is that what you're saying, Mr. Enright?
I'm sorry, Your Honor, I missed the first part of your question.
I said, are you quoting the Gonzalez case?
I'm quoting both because Gonzalez was quoting the guideline, but I'll quote the guideline to be clear. That's 4A 1.2 F, which is a, quote, diversionary disposition resulting from a finding or admission of guilt or a plea of nolo contendere in a judicial proceeding is counted as a sentence under section 4A 1.1c, even if a conviction is not formally entered. And then there's an exception for a juvenile diversionary disposition, but there's no dispute that this is not a juvenile disposition. And I think that is controlling because a prayer for judgment continued is exactly that. It follows a finding or admission. North Carolina,
the only state in the union that has something like it's called this?
As far as I know, Your Honor, it is unique in this procedure. I have seen several statements that it is unique, and I've looked and I've spent some time trying to find something that's just like it, and I have not had any luck.
Yeah, but there is a guilty plea entered in the proceeding, right? But nothing ever happens after.
There is a guilty plea or an adjudication of guilt. Technically, the court has the discretion to impose a PJC after a conviction or a jury verdict also.
Is that the shorthand term? Is it used enough? They have that, Judge Richardson used that term PJC, you did. It's used enough in North Carolina that people understand the acronym PJC?
They do, Your Honor. I see it routinely in sentencings in our office, and we have a few regular practitioners from State ADA's office, and it is a very common term here. I never heard it till I moved to North Carolina myself, but I've heard it so many times since then that it's definitely a common disposition.
Plead them guilty and try to get a PJC. That's the goal, isn't it?
Yes, and the guidelines accommodate that because it is a show of leniency. You have the conviction, right, and you admitted your guilt, so there's no question you did it within, at least as determined by a court. But you don't get the penalty associated with a judicial sentence. And to answer Judge Keenan's question, what's it a diversion from? It's a diversion from the judicial process, and that's right at the beginning of the statement. Diversion from the judicial process without a finding of guilt is what that guideline is referring to. So it's not
now, in the federal system. In the federal system, you still have a pretrial diversion program once in a while.
I'm aware of it. I honestly have not had a case that required me to look in any detail about it, but I believe
okay,
there are programs to that effect for certain offenders.
And maybe they do them in some districts and not others. I'm sorry, Judge Keenan, I've interrupted you twice, and I apologize.
Oh, no, not at all.
Go right ahead.
Was that you or me, Judge? Let me just ask if you're familiar with this Bagari decision. This is the 1993 decision, and it applies to a Maryland statute. And in the Maryland statute there, it looks a lot like a prayer for judgment continued to me, but it's not going to help me to ask you about it if you're not familiar with it. Is that?
I can tell you I read it, but I'm not remembering exactly what the dispute was in that case because frankly I read too many cases on the subject. I'm sorry about that.
Where and this is the Maryland code. It's called I don't know that they have a technical name for it, but it's a guilty plea without entry of judgment, and it's a particular statute that says after you plead guilty, the court may stay the entering of judgment and defer further proceedings. We, in that case, go under, and we find under 4A 1.2F that it is a diversionary disposition. And then we go on and address other issues, but that's the premise. And so I guess I'm just looking to you to help me understand, are you aware of sort of material differences with that Maryland statute that we already addressed in 93 and the prayer for judgment continued, understanding they're not exactly the same, but are there material differences that I should be aware of in thinking about the case?
I'm not aware of any material differences. I think the dispute that you see and that I saw in a lot of cases, and I think this one too, but I apologize, Your Honor, I'm a little fuzzier than I wish I were, but the fight is often about whether there was a conviction, because there are some diversionary schemes in states, and I think there might be some in North Carolina, where you're charged with something, and you have some kind of you take a class, and then there's no conviction, and sometimes it's fuzzy. And the guideline explicitly calls for an adjudication of guilt, either a guilty plea or an admission or a conviction. And that is the dispute. And that is, not only is it, and I want to emphasize, that is, I think, a hallmark of all PJCs or prayers for judgment continued in North Carolina law. But I don't even know that the court needs to go that far if it doesn't think that's appropriate, because we have undisputed in this case that there was a guilty plea. And so a diversionary disposition after a guilty plea, even if it's not in every case, is enough. I also want to
I thought these pre-trial diversion programs were talked about in the U.S. Attorney's Manual. You're not familiar with that?
Well, I'm familiar with the U.S. Attorney's Manual, Your Honor. I'm familiar.
I'll answer that one for him, Judge King. They are.
They're discussed in there, and they came from. I'll go back. I'm gonna give you some history here. 50 years ago, we called them the Brooklyn Plan. Mm-hmm. The Brooklyn Plan. They started up there in the Eastern District in New York, when they would catch kids stealing checks out of the mailboxes on the 3rd of the month, Social Security checks, and they would. And they put them on the Brooklyn Plan, and the prosecutor and the agents would do it all in the prosecutor's office and didn't involve the court. And the people in Washington didn't like these things when the courts weren't involved and didn't have the admission of guilt that you're talking about. and they kind of outlawed the Brooklyn plan or improved on the Brooklyn plan and got into what they formerly called a pretrial diversion program. But they were, I think, left kind of discretionary with the different U.S. attorney's offices. But this thing in North Carolina just sounds like a state version of it to me. I didn't mean to take all your time.
Well, I apologize, Your Honor. I am familiar with the U.S. Attorney's Manual. I am familiar with the existence of federal diversionary programs. I am, unfortunately, and this is my failure, I'm not terribly familiar with the details of them, and I'm sorry about that. That's my own lack of experience with them. One thing I've learned preparing for this case is that there's a lot of different ways to do it in the various states and in the various jurisdictions. And so I think the guidelines make it pretty simple. Does it follow a determination of guilt or a guilty plea? And is it a diversion, or is it, the alternative to a diversion is it's a judicially imposed sentence. It's a probation, or it is a sentence, in which case it's counted under other rules. And to go back to a question Judge Keenan asked, if there were no diversionary disposition, if this court were to conclude that a prayer for judgment continued was not a diversionary disposition, then the rule that would apply would be 4A1.2A4, which applies where a defendant has been convicted of an offense but not yet sentenced, because that's essentially what happens. You have a conviction, and then there's the prayer for judgment is continued, so the sentence isn't imposed. And lest there be any, sometimes there's some dispute about what the word conviction means, but fortunately the guidelines define it in that very section. Convicted of an offense means that the guilt of the defendant has been established, whether by guilty plea, trial, or plea of nolo contendere. So if it weren't a diversionary disposition, it would still get a point under 4A1.1c, because there's that conviction. And I think the idea of a diversionary disposition is simply to clarify that, I think the point of 4A1.1f is to clarify that, those count and they're considered a prior sentence, even though it may not technically, meet the dictionary definition of sentence. I don't know if the court has any, one thing I want to address just very briefly is the immigration statute. The 2L1.2 uses the term diversionary disposition, and this court incorporated, because it's an immigration guideline, the immigration statute's definition of conviction. That definition explicitly includes a requirement that the disposition include punishment or conditions. It doesn't apply to 4A1.2 because the decision, Medina, by this court said that we're applying a different definition for this section, and because the section in the immigration statute doesn't use the term diversionary disposition. There's simply no reason you'd incorporate that language in 4A1.2, and I don't believe I've seen a single decision that's ever done that. If the court has no further questions, I'm happy to yield the balance of my time back to the court, but if there are any other questions, I'm happy to answer them too.
Thank you very much, Mr. Enright. We appreciate it.
Thank you, Your Honor.
Now, Ms. Akawa, you
Thank you, Your Honor.
reserved some time. You got
Yes,
rebuttal
Your Honor.
time.
The court inquired about the U.S. Attorney's Manual dealing with pretrial diversion. Yes, there is a program under the manual, and part of the program is an alternative to prosecution, which seeks to divert certain offenders from traditional criminal justice processing. Amongst the things that it does is, if participants who successfully complete the program will not be charged, or if charged, will have the charge against them dismissed, unsuccessful participants are returned to the court. What Mr. Miller received was not a diversionary program. I will also ask the court not to use Maryland law, the Begatti decision, to decide North Carolina law. Just like I said before, this court looks to state laws to determine is somebody an armed career criminal. For instance, you make decisions. Is North Carolina breaking and entering a violent felony? Is Georgia breaking and entering a violent felony? You don't make a decision saying because North Carolina breaking and entering is a violent felony, that automatically means South Carolina B&E is a violent felony. That means Georgia is a violent felony. Page 20 to 22 of my brief listed a number of cases that says if there are no conditions imposed, it is not a final judgment. There's no dispute that he pled guilty. The question is what happened after that? Judgment was not entered. It's not a question of judgment. It's a prayer for judgment continued. Judgment was not entered. So yes, it is a conviction. Judgment was not entered. He wasn't required to do anything. He could not be hauled into court for doing anything because of that judgment that was entered in 2014. He walked away, the case was over. So it's not a diversionary program. It is not a final judgment. As North Carolina law says, if a PJC is not a final judgment when only costs were entered, there were no costs in this case. A PJC is not a final judgment merely because a condition is imposed ordering the defendant to obey the law. And you have some North Carolina Court of Appeals cases. It says, a PJC doesn't convert into a judgment because a defendant cannot appeal it. It is not a final, it only becomes a final judgment when certain conditions are imposed. And those conditions, for instance, are imprisonment, even if it's suspended, restitution, participate in psychiatric treatment, follow curfew. And I cited all those cases on page 23 of my brief. In this case, judgment, he pled guilty, walked away from court. A prayer for judgment continues. It is not a sentence, it's not a diversionary program. We shouldn't use
Ms. Okarwa?
Maryland law to decide North Carolina law. I think the court should go by how have North Carolina decisions. Yes, Your Honor.
I'm sorry, this is Sarah, the conference manager. All of your movement is causing the video to
Yes, Your Honor.
stop. Yep.
So I'm saying, Your Honor, it is prayer for judgment continued. It is not a final judgment. I've cited all the cases in my brief, and it's not a diversionary program because he wasn't diverted. He wasn't required to do anything. He entered a plea and walked away. He didn't even receive a suspended sentence. There were no conditions attached, so it doesn't qualify as a conviction. Well, it's not a final judgment under North Carolina law, so it doesn't qualify, and it's not a diversionary program for purposes of the sentencing guidelines. And I think it should be decided, as this court always look to state law in determining, is this a felony conviction? Is this an armed career case? Is that you look to North Carolina law, and under North Carolina law, what Mr. Miller received for the possession of marijuana was a prayer for judgment continued. It wasn't a final judgment. He wasn't required to do anything, and no criminal history point should have been assessed. And because the district court erred in doing that, his criminal history went to a level 6, and he received a sentence. The bottom of the range he should have received was 46 months, and he received a sentence of 63 months. And we're asking the court to remand it for resentencing without that criminal history point, and he should be sentenced as a prior record level 5. And I'm ready to answer any more questions the court has. Yes, Your Honor.
I think we understand your position clearly. We appreciate your work.
Thank you.
You're court appointed here, and we particularly appreciate your assistance to the court.
Thank you.
We'll take, Madam, and if we were in Richmond, I'll tell you, like I did the previous lawyers, if we were in Richmond, we would leave the bench and thank you and shake hands with you and congratulate you on your work in this case. We'll do that next time.
Thank you, Your Honor.
Madam Clerk, we'll take this case under advisement and we'll adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court. Judges, I will move you to the